Good evening, this is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday from 5 p.m. to 6 p.m. we bring in the immigration updates. Along with me is my business partner, Reddy Neumann. Emily, what do we have today?
Today we wanted to talk about H-1B lottery fraud allegations when a company is working with other companies to submit the same individuals multiple times in the lottery to game the system. What to be aware of in that situation. We'll also be talking about applying for marriage-based green card. We don't talk about that a whole lot on here, but it's becoming more common when people's applications got separated in the employment-based process. Now the main applicant has a green card and is able to sponsor the spouse. So how does that work? What are the requirements to be aware of there? And we'll go into a deep dive on H-1B transfers, how to navigate that process, what to be aware of. And then lastly, working on the EB-1C green card. So that's multinational manager or executive. If you're already in the US, maybe you're on your H-1B and you're stuck in EB-2 or EB-3, a lot of people are asking their employers to look into whether they might qualify for EB-1C if they already worked for the company abroad before they came to the US, or if they can go back to work for the company abroad in order to work for 1 year to qualify to come back. So we'll talk about how you can negotiate that process with the company as well as the attorney that's representing the company.
Emily, one person filing for multiple H-1Bs from different companies. There are some lawyers that said they can do it. Why are you telling it's fraud?
Yeah, it's definitely, there are shades to this. We're not talking about the situation where someone has a valid job offer from Amazon, Coca-Cola, and Home Depot, and all three of those companies submitted their name in the lottery. Totally fine there. What we're talking about is companies that don't actually have a job offer, that are coordinating with other companies. A lot of time they have shared ownership or same husband and wife, or different groups of people that all have companies that they've created for this purpose. And they just work together to enter the same names multiple times. Sometimes they're just changing a passport number to try to get in there multiple times so that the system doesn't pick it up. And so those definitely are not allowed. Even though, yes, they're separate companies, the whole purpose of being submitted with those separate companies is meant to game the system in order to unfairly increase your chances in the lottery. And we don't condone that. It should not be allowed. We would like really to eliminate this ability of people to file multiple times. But until the law changes, we're stuck with this system. And what USCIS tends to do is go ahead and run the lottery anyways, select people multiple times possibly, let them file the petition, give them the approval of the petition, and then they come back and revoke it and say that because you, did this fraudulently, we're going to revoke the H-1B as well as take away your cap number, so you're now subject to the lottery going forward.
Emily, have you seen any of the notice of intent to revoke for any of these cases, or you're just making it up?
Oh, we've seen them constantly. At least 5 times a week nowadays. We're getting these, not for our clients, but we are consulting with people who are receiving those kinds of NOIRs. They have not started anything for this year's lottery yet because that filing window has just opened. But I would expect after October, we'll start to see some of those. But we're definitely seeing this for people that did this last year.
In fact, I have to tell the people that this is the most common consultations that we get when people are getting the notice of intent to revoke. We do have a daily conference call also. Every single day, we do get multiple people reporting that they got a notice of intent to revoke because they have filed with multiple companies. This is the most common. So when you get this one, please contact. If you are one of the person who got selected in the lottery through the multiple H-1Bs, you may want to contact a lawyer to see if there is anything that can be done right now. As Emily has pointed out, they haven't started the fiscal year 2024. That's a problem, Emily, that they don't do it before. They wait, they approve the H-1B, and they then issue the notice of intent to revoke. This is causing a lot of problems for the people because, hey, one thing is that it's not coming to public. They're getting the approval, They're telling other people, look, I filed for 10 different companies. I got selected in the lottery. You, who work for a genuine company, filed a genuine H-1B, never got into the lottery. So now everybody tries to tend to the fraudulent work. I also noticed, Emily, that recently in the US consulates in India, they have been hit with misrepresentation for cooperating with these companies. That means there is a lifetime ban for these people to ever come into the United States because they have given their resume, their passport to these fraudulent companies, knowing that these companies are going to file in multiple H-1B applications, even though they don't have a genuine job opportunities for those things. Emily, let's say, for example, I get the H-1B in this kind of multiple filings. And on November, when I get the October 1st, I may work for a month. In November, I move on to Coca-Cola Company. And will I still be facing any problems, or am I scot-free?
Yeah, just because you've moved on to a different company does not make the problem go away. So they still, regardless of whether you work for the company, even if you aren't in the US, they're still going back and looking into those petitions, looking for those matching names, matching company addresses, using the same FedEx account, having the same kind of signatures on the paperwork. And they don't care that you've moved on to a new employer. They're still going to issue a notice of intent to revoke for the petition that they approved for you improperly. Once that's revoked, they can then go to your next employer and issue a notice of intent to revoke or a notice of intent to deny at the time you file an extension or an amendment with that company. That company has nothing to do with it, but what they're saying is, hey, because of the fraud, this person is not counted in the lottery, and therefore we cannot issue an extension, or we cannot approve you for this amendment, or we're going to revoke this approval because it is dependent on the fact that you got through the lottery through fraud. And so, yes, it will follow you to every subsequent petition that you file with the Immigration Service. It may not happen overnight, but it will eventually happen.
Emily, anything else before we move on to the next topic?
Yeah, one of the questions was, what can you do if you were not a part of that, if you're not aware of that and your company did it without your knowledge? And we do see that quite often, unfortunately. And that's where the difficulty comes in, is USCIS will still say that when the petitioner acts fraudulently, the beneficiary is the one that won't be counted in the cap. Now, that's not actually what the statute says. It requires the beneficiary to actually carry out the fraud. And then in that situation, the beneficiary is the one that is punished for that. But they're still trying it, even if the beneficiary wasn't involved. So many times that comes up with your next company, or when you filed an extension and you're not aware of it, you find out about it then. The other company now has to try to respond on this issue that they know nothing about. They may not be willing to respond. Or if they do, they might not want to get involved. But eventually, if it does get revoked, you as the employee, who's the innocent victim here, may have to sue the government to get them to reopen that petition. And if they're going to find fraud, make sure that they don't find any fraud on your part so that you can keep your cap number. Otherwise, it's going to haunt you, even though you were not involved in it.
A lot of people are asking questions with regards to, what if I am a nice guy, I filed with a nice company, let's say Coca-Cola, and I never got selected in the lottery, and I see the other people the other companies doing fraudulent, what can I do? We recommend that you report this one to the USCIS. There is a fraud report. When you report, give them a specific things though, that this is the company, this is the address, this is what they are doing. Give the specific details to them. There's a good chance that an action will be taken against them. Please do that thing. And if you get some offers from the company, I see that some of the Facebook, they say, hey, just give me your passport, I'm going to file you the H-1B. They don't even want to look at the resume. That definitely is a fraudulent thing. You can report that to USCIS. I did report that to the USCIS, the one that advertised on Facebook, saying that he doesn't even need a resume to file a H-1B. All he needs is a passport information. That's definitely wrong, and the way they did it. So please report that to the fraud detection unit of the USCIS. Now, when it comes to we're going to move to the next topic called marriage-based green cards. What are the do's and don'ts of it? The first thing is that there are typically two kinds of marriage-based green cards. One is based on U.S. citizen filing, and one is green card filing for the spouse. A lot of people, they don't go to the lawyers. We strongly recommend to go to lawyers. When the person is in United States, though, you need to file I-130, I-485, and I-765, and you also need to file I-131, along with the I-864, that's another form. So please, don't just file an I-130 and go to a lawyer. That's better is to file all the things together would be a better strategy rather than not filing. Now, if you're going through consular processing, of course, you can't file all these things. You have to file an I-130. Be prepared that the whole process might take 2 years plus for the person to get the green card, though. A lot of people, I'm a US citizen, I'm getting married with this person, I'm going to file an I-130. Can I get the green card for my spouse for 6 months? No. If the spouse is outside the country, it may take 2+ years for them to get the green card. And it becomes very frustrating if you don't inform the girl, hey, you're going to take 2 years to come here. You say it's only 6 months. She is going to cry, crib, whatever she is going to do it. I understand why she's going to do it. So be prepared for those things. And especially there's other things. If somebody is coming with an intention to get married into United States and then convert into green card, and they're coming on a non-immigrant visa like B2 or F1, that is strictly not allowed. And there are people who do that and they get caught and they get deported, and that's a big problem. They may never be able to come back into the United States. Now, however, if they come into United States without having an intention of marriage, but if they change their intention, it's perfectly okay. And people may ask question, how do the USCIS, how do the CBP find the intention? Well, you do WhatsApp. In the WhatsApp or other communication that you do, Snapchat, whatever you call it as. And then if you're communicating with them saying that you're coming here for the green card, that's definitely a thing what they catch up with you. So nowadays, the electronic communication is monitored by the government. And you, computer programmer guys, are the guys who are writing how to monitor it. So don't ask me how they monitor it. You are the computer guys. You should know it, how they monitor it. So yes, those intentions are very clear. When you're filing for the 485 application for the marriage base, be prepared that the petitioner, that is the green card holder or a US citizen, must be financially good enough. There is a poverty level, which is about 40,000 or 35,000 per year. But if you don't meet, there are some alternative things where you can get a co-sponsor, where your uncle or your cousin or your friend can help you out in sponsoring your spouse. So be prepared for that. And the timelines, you need to be prepared. The EAD might take 4 months to 8 months. Advance parole might take 4 months to 13 months. And there are some travel restrictions if you file an I-130 and I-485 application. You cannot leave the country until you get an advance parole. There are some exceptions available for a H-1B and L-1, but do consult an immigration lawyer before you embark on the journey of traveling outside the country once you file the 485. That becomes a big problem for us, that when people file a 485 application, they just leave the country thinking that, okay, they're going to come back after the advance parole comes in. Or sometimes they think that they can come back on a B2 visa that they have, or an F1 visa. No, you can't come back on F1 or B2 visa. You need to wait for an advance parole. And for the marriage-based applications, so try to gather as much information as possible that you both live together. Pictures, especially I'm more interested in the group pictures, not you and your wife going to Las Vegas and taking a picture. I'm not interested in it. I want more family pictures. I want more group pictures. The USCIS is going to ask, where did you have taken the group pictures? Group pictures are very important. Any travel that you have done together, lease agreement might have, that has both the names, income tax returns, bank statements, credit cards, insurances on both names, car insurance on both name, and any other documents that says that you both are living together is very important when you go for the interview. Don't try to collect this information just before you go to the interview. From the starting itself, keep collecting the documents. It will become easier for you. Normally, ask a lawyer, what are the living together documents? The guy gives a list of it. And then you keep collecting, put all of them in one box, okay? And then at the time of the interview, you can organize them and go to them together. Anything else, Emily, that I'm missing?
Yeah, and just be aware that there is likely to be an interview. It's not like employment-based where the general rule is most people are not interviewed and only a few are. On the marriage-based cases, most people are interviewed, and they've only recently started waiving some interviews. So expect that you're going to be interviewed. And as you said, make sure you are gathering documents from the very beginning, not waiting until you get the interview notice and just getting documents at that point. And other things to be aware of, that, if you are in the U.S. in a non-immigrant visa that does not allow you to work, it could be many months before you get that EAD card to be able to work, to get the social security number, to be able to add your spouse to the bank account and those sorts of things. So just plan for that and make sure that you have the means to support yourself while you're waiting that long time for the EAD, because you can't work without authorization, even though your green card application is pending.
Let's move on to the topic of the transferring of the H-1B visas from one company to another company. What you need to be careful about. The number one problem we see is that if you are working remotely from your home and that remote location is not in the same location of your employer though, or the end client location, please make sure that the LCA includes both the locations, that is the place of the employment, whether it's an end client or your own, if you're a direct client, the employer location, and also your apartment location or your house location. That's the most biggest mistake we see in when people are transferring the H-1Bs. It's always good that when you're transferring the H-1B, before you give the notice to the previous employer, try to file a H-1B with a new company. That will be much easier for you to have the H-1B filed before you move to a different company. You may want to look into considering to premium processing to transfer, especially if you have any travel things to do. You may want to have that when premium processing. Especially if you have any travel plans, please mention it to a lawyer. There are some restrictions, especially when the H-1B transfer is pending. If you want to travel and come back, though, that may become a problem. Yeah, it's better that you travel and come back and file the transfer. That's one way that you can do. Do the premium processing, get the H-1B approval, and then go outside the country and come back in. And also be prepared, just in case, if there is a denial of the H-1B, what is the next action course that you're going to do? There are sometimes we made an argument that the 60 days is applicable when you get the denial to move on to company C. That has been successful, but be prepared for it. Whether do you have an H-4 option? Those are the things that you may be considered before you embark on the journey of transferring to another company. Anything else, Emily?
Yeah, and once you do transfer, number one, you do need to provide those recent pay statements from your current employer, unless you're within your 60-day grace period. And you also need to think about whether you're going to join based on the transfer being filed or wait till the transfer is approved. Now, of course, waiting until it is approved is a safer option. Because you know at that point that it's is locked in and there's not going to be a denial at that point. But of course, if you lost your previous job, you don't have that option. But if you're choosing to leave, the most important thing is to make sure that the transfer is at least filed before you notify the other employer, and you can join the new company as soon as the transfer is filed. Or you can choose to wait for the approval. You could request premium processing to help speed that process along. And one other thing to be aware of is once you have your transfer approved, if you have a visa stamp in your passport from your old employer that has not yet expired, you can still use that to travel as long as you have the new approval notice once you've joined the new company. So your old visa stamp is still valid, even though it has the old company's name on it and has the old company's receipt number on it. You can use that to enter with a new company as long as it's not expired and as long as you have the I-797 approval notice to go along with it. Just make sure when you do enter that you verify that they give you the correct end date. Sometimes CBP will give you only the end date that's on the visa, not the end date that's on your new approval notice. So verify that before you walk away, because it's easier to fix it there at the airport than it is after the fact.
Let's go to the next final topic that we have discussed today is that how to negotiate to get to the EB-1C green card application. This is a big issue for a lot of people who are eligible for EB-1C, and the employer may or may not be willing to file the green card application. So when you go to the employer's lawyer or the HR, though, be prepared for you to understand what does it require to qualify for EB-1C. Does it require that you must be multinational executive? What is exactly required? Are you shooting for multinational executive? Are you shooting for the functional manager? If you're shooting for the multinational executive, how many employees you're supervising, and what percentage of your job duties are supervision, what percentage of your duties are to the hands-on work. So you need to be prepared for that. My recommendation is that when you're approaching the HR, when you're approaching the lawyer, if your supervisory duties are not more than 70%, then you may have a lesser chance of getting the I-140 approval. For example, I'm doing this show right now. Is that a supervisory duties? Is Emily also doing, is that a supervisory duty? Is it a management duties? No, it's not. It's an hands-on thing. So you need to divide your timing to see how much of your timing is a supervisory thing, how much of it is a hands-on thing. Especially if your supervisory and executive duties are more than 70%, you have a higher chance of approval. And if you have more than 15 people that you're managing and people who are reporting to you, you have a higher chance of approval. It would be better that you consult a private independent lawyer before you commit yourself to the HR or before you commit yourself to the company, because once you're committed there, once you make some statements there, you're stuck there. You can't get back from all those things. Emily does a lot of L1As and EB-1Cs. Emily, what are the other suggestions that you give?
Yeah, one other thing to be very careful of, and this is something why some attorneys or companies may be hesitant to go the EB-1C route, is you have to look back at the prior applications that were filed for this person. So many times it happens where someone has been working outside the US, probably in a managerial position, but they may be coming in on an L-1B because at that time it was easier to get the specialized knowledge visa approved compared to a manager L-1A visa approved. So in that application, the employer would have already gone on record talking about that job description from your time abroad, and they may have never once mentioned that you've managed people during that job. They're focusing all on your specialized knowledge. And now you're wanting them to go back and say, oh, wait a second. Yeah, they were doing specialized knowledge work, but they were also managing all these people, and these are the actual job duties. So they may have gone on record in the L-1B application at the consulate or with USCIS. If the company's already sponsored you for a labor certification, your job description abroad may already be listed on that labor certification, and it may not mention any of your managerial duties. And then when you submitted your I-140 for EB2 or EB3, you may have included an experience letter from that company abroad that doesn't mention any of your managerial duties. Now, when the company turns around and tries to file the EB-1C I-140, USCIS is going to say, wait, we think you're misrepresenting this job. You either misrepresented it then or you're misrepresenting it now because you didn't mention any of these managerial duties before. So it definitely needs to be something to be addressed. It needs to be looked into. You have to make sure that you're not being inconsistent with what's been stated all along, and are explaining how it is that even though the job duties before were focused on the specialized nature of the duties, the position was also managerial at that time. So that tends to be one of the sticking points from the attorney standpoint, is they're looking at what is the risk to the company. Is USCIS going to come back and claim that there's some sort of misrepresentation there? And I do see that happen from time to time. So you just need to be very careful of that. Look into your old experience letters that you've submitted. Look into your old applications. See what was stated there to kind of start that conversation.
And one other point that I want to suggest is that when you start the conversation, why I tell you to go to the independent lawyer is that it's like a toothpaste, guys. It's easy to get the toothpaste out from the tube, but you can't put it back. There's no way to put it back. It's very hard. So the statements, the words that you speak to your HR, to your immigration lawyer, you can't take them back. They're already spoken. So that's the reason where it's better before you speak with them, speak with an independent lawyer, try to get a determination to see what is better for you, and then go speak with your HR. Anything else, Emily, before we go to Q&A?
Nope, I think we can go on to the questions. So we can get started with Kem Lesh, who says, my 485 moved to a non-local office in a different state. What does this mean? Is there a concern? And what is expected next? So I would say prior to 2020, that was pretty unusual. And it usually meant the file got sent to the wrong place and we had to try to get it moved to the correct place. Maybe they have a wrong address or something like that. But nowadays, this is quite common. They do move the applications around to different field offices that may have more officer availability and more time to adjudicate these applications. So nothing to be concerned about. You may get a request for evidence from that non-local field office. That's usually a good sign. That usually means they're not intending to interview you. And so once you respond back to that request for evidence, if the date's current, they are able to process the case to approve it. If the date's not current, they'll just either hold on to it or send it back to the National Benefits Center. But most likely nothing to be concerned about.
Emily, Tala Cheru from YouTube has this question, which I need your involvement in it, and this happens very frequently. My employer informed me that the revocation is due to multiple filings, companies, and refused to provide me with a copy of the notice, FOIA yet. I'm not able to find the records in FOIA also. What's the solution?
Yeah, that's tough because as the beneficiary of the H-1B, you don't have the power to request any information from USCIS. You technically don't even have the power to respond to the notice of intent to revoke as the employee because you're not a party to that petition. It's just done on your behalf. And without knowing what's in the NOIR, you can't really respond to it because you don't know what you're fighting against. So you may have to do the FOIA again. It's possible that the record wasn't updated by the time that you made the request. It's possible, I'm assuming at this point you're no longer with that company since they're not cooperating with you. You just may have to continue to monitor the case status to see if it eventually shows up as revoked. And then just hope for the best with your current employer. Be prepared that there may be a notice of intent to deny or a notice of intent to revoke on their application. At that point, that company would need to respond to it. And then if it's revoked, that's when you as the employee, as the beneficiary, maybe then be able to go to court and litigate that on the grounds that you have no involvement in it and you're the only one that's suffering based on this fraud that was done on the part of the company. It's a difficult situation because just USCIS won't talk to you or listen to you. So you kind of might have to be in a situation where you wait and see.
Mr. Singh from YouTube has multiple questions. I'm going to answer 3 of those things. Will the notice of intent to revoke, will it be a problem at the future H-1B lottery? It didn't used to be, Emily, before, but recently I got some consultations that some fraudulent company filed an H-1B long time ago. Like I will name the person of the company. His name is Raj Kosuri. He filed thousands of H-1Bs. Of course, he went to jail or something like that. Now, this lady filed an H-1B, went back and got the H-4 after the second H-1B that she transferred got revoked. She got the H-4, came back, filed the H-1B. Now she went back to India to get the snapping. And they issued a 221G and they refused the H-1B and they sent the H-1B for revocation. And so, yes, when you deal with the fraudulent companies, you may get affected lifelong. And there are some people who got banned permanently because of misrepresentation because you cooperated with these fraudulent companies. Then Mr. Singh is asking, what if they filed without the knowledge? Well, if that is the case, though, definitely there may be some legal action that you can take against that particular company to see if that legal action may actually help you in the immigration matter at a later date because you sued that company saying that, hey, you filed on my behalf. Now I got paid. I'm the victim for it. So you pay me my damage. You go and sue that guy. That probably might get some gain. Maybe you should complain to the USCIS that they did it. Then it will be a record for you saying that, hey, I filed a complaint with the USCIS that they did multiple filings without my permission. The question also Mr. Singh is asking is, after H-1B is revoked by USCIS under this consideration, do they get the 60-day grace period? No. The whole process, what the USCIS is telling is, you are never being counted toward the H-1B number because the H-1B is a fraudulent H-1B. So you don't have the 60-day grace period here. You're out. So that's the reason why involving these fraudulent companies is bad. Now, we did mention very many times before the quota that not to go with these companies, but what can we do? Now we see that 50% of the H-1Bs that have been filed, according to the stats, are multiple filings. Is that right, Emily? Or probably more?
I mean, it has to be, given where the economy is right now. And, we won't know really till June 30th when we see if there's going to be a second lottery. But there's just no way, and again, we don't even know how many were actually registered. But the fact that USCIS isn't sharing that information, I think, is not a good sign.
Yeah, it looks like we are going to get a lot of these revocations, Emily. So we need to be busy for our consultations.
Yeah, Morelli says, can an H-4 EAD continue their job after it expires if the H-4 extension has been approved, but I'm still waiting for the approval notice in order to apply for the H-4 EAD extension? No. You can only continue working if the H-4 EAD extension has been filed before the current EAD expires. So if you're sitting around waiting for that approval notice to come, and while you're waiting, your EAD expires, and then you file the EAD extension, you do not qualify for the 540-day automatic extension. Stop waiting for the H-4 approval notice and just file the EAD application so you can get that receipt notice. Then you'll have the approval notice, the H-4 approval notice. It has the I-94 on it showing it's been extended, and you'll have the H-4 EAD extension receipt notice. Those two combined allow you to work. You don't have to wait for the H-4 approval notice to file for the H-4 EAD. Now, yes, you'll probably get an RFE later asking for that approval notice, but at least you would have timely filed it so that you can qualify for that H-4 EAD auto extension.
Param Kunar from Facebook has this question. He has moved as a program manager from India and other countries. He used to work for that same company in India and other countries. And he moved to USA on a H-1B. He supervises hundreds of people, managing hundreds of workforce for the company. They filed the green card in EB-2. Can he now file the green card under EB-1C? Does the fact that the EB-2 filing prohibit the company in not filing EB-1C anymore? Absolutely wrong. They can still file under EB-1C. Even though they filed under EB-2, if you are qualified under EB-1C, they can still file under EB-1C. The fact of the matter that you came on H-1B instead of L-1A, still not a problem. You can still file a EB-1C. In fact, when you file a EB-1C, you can put the date that you have on EB-2 and convert into EB-1C application. So definitely you should approach the company and make sure that you get an EB-1C. Not only that you must be supervising, direct supervising to a lot of people, but also your job duties must involve more of the supervising, and less than 30% of your job duties should be hands-on work. That's also important. Yes, you should request your company to file EB-1C, Mr. Param.
Pujita was on OPT back in 2017, and when filing for that EAD, joined AZ Technologies. This is the company that was handing out fake offer letters to students so that they could avoid the going over the unemployment limit. They supposedly had so many students that were working for them, just the same number as Amazon, which you can guess is probably not the case. So later the government found out that this was not a valid company. So this person had joined as an intern and was there for 4 months. Now I'm going for H-1B stamping. Will there be a problem? So there were definitely people who were bamboozled by this company, thought they were getting a valid job offer, showed up to do work, and were given some random trainings to do. I've seen some of the trainings and emails that they sent out. So there are genuine people that were caught up in this. But be prepared. You probably are going to get a 221G when you go for stamping. Number one, if you qualify for the drop box, most of the time we see that when you go to drop off your documents, they tell you, nope, now you need to come in for an interview. And then when you come in for the interview, then you're going to get a 221G delaying your visa application while they look into what your particular situation was. Were you actively aware and doing this knowingly and not working, or were you an innocent victim in this? So I would recommend don't go for stamping. Don't leave the country if that's not an option. If you've already left, when you're filling out the DS-160, if you're claiming that you did work there as an intern and you actually did attempt to work there, you need to list this company on your employment history, because if you don't list it and they're aware of it, they're going to think you misrepresented your employment history to try to cover it up. So you have to be truthful that you were there as an intern in your DS-160, and then be prepared for the interview to explain how it is you got involved with this company, how you heard about them, what your job actually was, what were you doing, what were your attempts to try to get employment with this company, so that you can show that you were not part of any of their fraudulent activities. But even after all of that, yeah, expect there to be delays in 221Gs. I see that almost every week.
Reddy has this question that once the H-1B is revoked for multiple filings, how long can you stay? Can we appeal it? This is a very tough question. I would recommend that you contact a lawyer, though. Can you change the status from H-1 to F-1 after it's been revocation after it's been revoked? The answer is no. You may not be successful in getting the F-1 approved, because the USCIS may say that you did not maintain the status because the H-1B was never a proper status for you because it was fraudulently filed. Definitely, F-1 is not a good option. Question that comes from Good Time Forever. Nice name for YouTube. We have filed an EB2 from EB2 to EB3 I-485J. My employer terminated and advised the USCIS that they're no longer the sponsor. What will happen, the status, what will happen if I don't get a job immediately to transfer, though? One thing is that since you have an EAD, it's more than 180 days. If you get a job, it's definitely easier for transition. No problem with it. The new company will take over the 485 application. They don't have to immediately file a 485J supplement. When the RFE comes in or when there is an interview, you can file it. But if you choose, the new company can file a 485J supplement, you'll be in a good shape. But if you don't have the job with the new company, though, there are some alternatives available, but I want you to consult a lawyer for it. One thing is that self-employment, which the USCIS is going to test whether or not you're self-employed, or your wife can employ you. That's another thing that you can, wife or spouse can employ you. That's another thing you can consider for it. But those things are a little bit riskier. We definitely want you to consult a lawyer. Getting a job immediately with some other company is definitely there. Now, are you allowed with a 60-day gap period if you lose a job on 485 EAD to join another job? We don't know the answer for it. And we don't want to know the answer for it. And we would like to restrict it so that later on, if the USCIS says, no, you don't have a 60-day, because legally there is nothing that says that the 60 days is allowed. You must have a continuous job offer. So the USCIS may deny the entire 485 application if you don't have the continuous job offer. So it's better that you consult a lawyer if you don't have a job offer right now in your hand, if you lose the job.
GK re-entered the U.S. using the advanced parole and then filed the renewal for the advanced parole, which is still pending. And now he's wanting to take a quick trip to Mexico for the summer and wants to know, if he doesn't get that AP renewal approved before the trip, can I enter the U.S. with a valid H-1B I-797 with the I-94 on it? So yes. So just because you return to the US on the AP, it does not make your H-1B go away. So assuming that you're still working for that H-1B employer under the same terms and conditions of that H-1B approval, you are considered to be maintaining your H-1B status, and you can exit to go to Mexico and use automatic revalidation to use an old expired visa stamp and come in with your valid I-797 approval notice that has the H-1B I-94 attached to it. You may have to refile the advance parole once you return, but yes, that is doable.
Santosh Kumar has this question. I'm an H-1B, got an offer with another company. They have done the visa transfer, but now I'm not planning to join. Will there be any negative impact on the status? Well, I'm not a moral guy. I mean, I'm not a moral police guy. I'm just a lawyer guy, so don't blame me on it. As a lawyer, as an immigration lawyer, I'm advising you, Santosh Kumar, you will have no problem, none whatsoever at all, if you don't join that company. Will not impact your H-1B, will not impact your green card, will not impact anything if you don't join the company, even though the H-1B has been transferred.
MM is a U.S. citizen who applied for the green card for the parents, and it's been pending for 9 months. I-130, I-485, 765, 131, all still pending, no updates. Now the parents want to travel back to India and wants to know, is there any suggestion there? So they definitely need the advance parole to travel. If it is not a life or death type of emergency requiring them to travel, your best bet is probably litigation. Because they can request an expedite of the I-131, but USCIS really only approves those in severe life or death type consequence situations. So without that, if they're just wanting to go back for a visit or something like that, they need to get the advance parole, and our experience has been litigation is successful in that. We sue multiple times for what we call interim benefits, delays in those cases. So we do see good results when suing for I-765 delays as well as I-131 delays. We include them in one lawsuit. Both parents can be included together. So if you'd like to explore that, you can reach out to Stephen Brown in our office. He handles that.
I would like to name the person who's asking the question. The person who's asking the question, he or she is on H-4 dependent visa, got arrested for Class B misdemeanor charges. The difference is on attorney says it can be dismissed. Can I still work while the charges are going on? Absolutely, you can continue working. If you have a H-4 EAD, you can absolutely, which you said you have, you absolutely can continue working. However, we advise people that whoever gets charged with any criminal charges other than simple traffic tickets, please consult an immigration lawyer. Even though the criminal defense lawyer says something different, we have a different perspective of it. For example, case dismissed. I mean, what do you mean case dismissed? And there is different ways. The case can be dismissed because the prosecutors might not want to go further with the case. The case may be dismissed because you paid $50 to the judge. I mean, not to the judge, but the court, saying that, okay, I will never do this again. Here's the $50 to the court, and they may dismiss. That will be considered as a conviction for the purpose of the immigration. For example, somebody is being charged with a shoplifting, and then they go to the court. Sorry, court, I will never do it, and all those things. I will pay the penalty, whether it's a 500, 400, and then you come out. That will be, and then the court will dismiss the case. It's considered to be a conviction for the purpose of the immigration, though. So, and you need to report that in the 485 application. You need to report that when you go to the consulate. You need to have the certified documents. I would recommend people to take at least 6 sets of certified documents, because you need it at the time when you go to the consulate. You need it at the time of the 485 application. You need it at the time when you go to the 485 interview. You need it at the time of going to the citizenship application. And the 2 extra things, nothing bad, because and then also can you seal this one? What is that? Expungement. That's the word that you used. It may be a good idea for you for the employment, other things. It's not a good idea for the immigration, though. So you may want to consult with an immigration lawyer to see that which way is better. For example, shoplifting may look very bad upon you. There are certain things, for example, DUI may not look that bad upon you. So there are things that that you need to see, do you need the expungement? Your criminal lawyer will say, yes, expungement is good, but our perception is different because immigration, when they look into this guy's been charged with a crime and they can't see it. Once they can't see it, now they're curious guys. What is this guy got charged with? Is it terrorism? Do I not know? So they get panicked on that when there's an expungement. And that's where the problem comes in. We are not in favor of expungement, but the criminal lawyers are. So once you talk to the immigration lawyers and the criminal lawyers, you can make your decision what you want to do after that.
Selva says, I filed the N-400 and it was approved on the spot last week during the interview, but I don't see any update on my portal yet. It still says interview scheduled. That's very normal. We see that even in employment-based cases and family-based cases. Once the file goes to the local field office, all bets are off on that portal. It may not update. As long as the officer, I'm assuming, gave you a document confirming the approval, or they told you that you were approved, I would not worry about anything that's on the portal at this point.
Question from Varuni Rao, filed 485 in January of 2023. Prior date is November 2010. Oh my goodness, you filed after a long period of time. Do I need to go through the LCA to file the H-1B extension? Still did not receive an EAD in advance parole. Extension approval under, should I go for the approval under the normal process? Yeah, you definitely need to go to the LCA. I don't know when your H-1B is expiring. Definitely, if the H-1B is expiring immediately, you need to file an LCA, you need to file an extension. Otherwise, you cannot continue working based on the EAD application, though, because this is your initial EAD application. You cannot work based on the receipt notice. So you have to get an approval. So if you don't get the approval, you should file a H-1B. Maybe you can wait until like a month before your H-1B expires. At that point of time, you can take action on the H-1B. You don't have to file like 6 months in advance. You can file 1 month in advance. But yeah, be prepared to file the H-1B because your EAD may not come in time.
SP says, I applied for the H-4 EAD extension and I'm still waiting for it. I updated my I-9 with my employer because I already have the I-94 extension and the EAD receipt. Now, is it possible to switch employers while I'm waiting for that EAD extension approval? Yes, you can. So that I-765 receipt notice showing that it was timely filed before your EAD expired, along with your expired EAD, and your H-4 I-94 that is still valid, all combined to show that you are authorized to work and you can work for any employer. So yes, you are eligible to change employers and would just show the new employer all of those documents in order to complete the I-9 process with them.
Ankit from Facebook has this question. He's recently got approved EB. He got an I-140 approval. His priority date is October 27, 2022. He wants to get the benefit of EAD and advance parole. His EAD and advance parole is also approved. When does the priority date becomes current? Wow, Ankit, that's a tough question. I can't tell. I don't know because the USCIS is telling there may be more backlog in the EB1 category at this point of time. So it may take a long time for your priority date to become current. I want you to be prepared for you to stay for a long term in the EB1C category, even though your I-140 is approved. Since you filed the 485 application, hopefully so in October of 2022, if it's almost 6 months, once you cross 6 months of filing, it's up to you if you want to change to a different company. As long as you move into the higher level management position with a different company, you can. Since your I-140 is approved, your 485 has been pending for more than 180 days, you can. But to get out of the 485 application and get a green card, be prepared. Be prepared to stay there for at least 2 to 3 years. That's what my advice. And keep watching the visa bulletin. That's all I can tell you.
Vikas says how to apply for a copy of the I-797 if UPS lost the package. How long does it take and can we travel without it? All right. So I'm assuming this is like an H-1B approval notice or an L-1 approval notice or something like that. and unclear whether it got lost getting from your company to you or from USCIS to your company. But let's assume that your company received it, they have the copy of it, but they sent you the original and it got lost. You may want to consider not even bothering filing for that duplicate because it takes so long. Only the company can do it. But for most everything nowadays, you can use a copy of the I-797. So you can use that to apply for a visa stamp and travel into the U.S. The consulates and CBP can verify the validity of that. But if the company never received it, only they can contact USCIS for that. So they might want to start by, if it's premium processing, contacting the premium processing service to see if they'll mail a duplicate out of courtesy or at least email a copy. Otherwise, yeah, they're going to have to file an I-824 application for a duplicate approval. It's got a $500 or so filing fee, and it probably takes 6 months to get that. So it's a long wait. So if you can avoid it in any way, or try to get it, have the company get it by contacting USCIS first, that would be a better option.
Emily, you said that with the copy of the H-1B approval, people can go for stamping. I agree with you on that. With a copy of the H-1B approval, they can travel to United States. I agree on that. Here is the problem: the stupid driving license. I can't get it without the original.
Yep. Totally agree with you.
Yeah. Now, when you apply for the duplicate, there is some alternative thing. If you really want it, though, if you're willing to spend a lot of money, which sometimes it happens, you can file a H-1B amendment and request in a premium processing. Now, that's a very costly method of doing it, though. But if you're desperate, you want it, and then you want to get it, you can file an amendment. And people ask me questions, what kind of amendment can I file? I didn't move out of the location. My job is the same thing. Well, let's say, for example, you're making $120,000. Well, you can make $120,000 and $120,005 extra. And you can file a H-1B amendment. You may not need it technically, but for the purpose of getting the duplicate faster, as Emily has pointed out, you file for the duplicate, it may take 1+ year for you to get it. This will get you in 3 weeks. So that's an alternative that I would suggest.
Pradeep says, what if the I-485 has been approved before I sent the I-485J to USCIS? I changed the job from the original 485 employer. How should I deal with this with USCIS in the future? Well, if USCIS wanted a supplement J, they would have sent a request for evidence asking for it before they approved your green card. Since they approved it without asking for it, you don't need to do anything, nothing to worry about there. You don't have to provide any documentation or inform USCIS at all. I don't see any issues at all.
Soumya has been continuously asking the question, a bit confused what do you mean by consular processing. But anyway, if you have some pay issues with your employer and you are on the H-1B, there is a form called WH-4, Department of Labor. Google that. There is a form there. You fill that form out, Soumya, and don't send it to the Department of Labor because sometimes that may close the entire company, though. I will prepare the form, send it to the company. Hey, company, pay me the money. Otherwise, I'm going to complain to the Labor Department. And if they pay the money, well, it's all done. Don't do anything. If they don't pay the money, send it to the Department of Labor. The address where you need to send it is already there in the form. I repeat again, it's called WH-4, Department of Labor. That's the one that you're going to type it in Google.
Chandra says, if I joined a new employer B using my green card EAD, what happens to my H-1B with employer A? And can I reuse it or transfer the H-1B to the new employer in the future? So the H-1B with employer A is still there. It's still valid unless it expires or the company withdraws it. But it's not that easy for you to now transfer that to employer B because you're no longer in H-1B status since you started working for employer B using your EAD. So in order, if you wanted to get back to H-1B in the future, the new employer would have to file an H-1B that is not subject to the cap because you've already been counted, but requesting consular processing because you're not currently in a non-immigrant status. Once that gets approved, you have to exit, apply for the visa stamp at the consulate, and then come back in. And while that's all happening, when you're leaving, you need to make sure you have a valid advance parole so that you don't abandon your 485.
Sham Patil has this question. He has traveled to Bahamas cruise multiple times on expired H-1B stamping. My H-1B extension recently got approved. I want to go stamping. Will there be any problem? I just want to tell people what exactly he's speaking about. Is that it's called automatic revalidation, though. Automatic revalidation allows people to travel to the contingent countries even if the passport visa expires. However, though, for the H-1B visa people, though, Jamaica, the Caribbean, is out of the list of the automatic revalidation. Mexico and Canada, they can do automatic revalidation. So please, when you travel for automatic revalidation, that means your passport visa expired, don't go to Jamaica. You are allowed to go to Canada and Mexico, but not to Jamaica. That's what his issue is. He has traveled multiple times, but he realized that it's a big mistake he did it. Sham, since now you got the H-1B extension though, and I'm not expecting any problem for you when you go for stamping, but never do that again. Never travel to Bahamas without having a passport stamping. The automatic revalidation is not eligible for the H-1B. Under limited circumstances for a student visas, it's a different story, but not for H-1Bs and H-4s. Automatic revalidation is not there for Jamaica or Bahamas. But now, I don't see any problem for you in going.
Another question about these possible H-1B revocations. What is the process to change status from H-1 to F-1? And will that be possible after the revocation of the H-1? So second question first. After the revocation, you don't have an option to file a change of status from H-1 to F-1 because anytime you're filing a change of status request with USCIS or an extension of status, you always have to prove at the time of filing that you were lawfully in the country and maintaining whatever status you were given. So if your H-1B has already been revoked, you're no longer in status, and you may be considered unlawfully present, you can't now file a change of status to F1. Or if you do, it would be denied because you were not maintaining H-1B status at the time of filing. Now, if you're...
Emily, I did answer the rest of the question to him because when the H-1B is revoked, can he transfer to the F1? I have indicated that it's a very dangerous thing to go to the F1 visa. I just want to let you know on that. Do you disagree on that?
No, I agree. Yeah.
It's because of the multiple filings.
Yeah.
I got my EAD and AP through my previous employer. It's more than 6 months and I got the approval. Is there any problem if I tell my current employer I got an EAD and AP through the previous employer? No, I don't see any problem in it. That to say your current employer that with the previous employer you got an EAD and AP. However, we have seen some of the companies taking it a little bit more offensive and saying, no, you have to go and join that company because they file your green card application, which is not true. But we have noticed that some of the companies will tell, no, the lawyers will tell you have to go and join that company. You can't work with my company anymore. So legally, you can tell it, but I don't know how the company is going to take it. If you think so that the job is very important for you, maybe you don't have to disclose that information. Keep continuing on the H-1Bs with that company without disclosing the EAD and AP. But if they are, depending on the other people, how they reacted, then it's up to you to disclose it.
All right, well, I think we're about out of time for today. Thanks everyone for joining us. And don't forget that we do have a free daily conference call where you can join and get your questions answered there as well. You can go to rnlawgroup.com to get the information for how to join that. And you can also subscribe to our newsletter by going to rnlawgroup.com so you get the latest updates every week.
And if you want to make a consultation with any of our very good lawyers in our office, you can always go to RN Law Group. Our appointments are available online. So you just need to go to rnlawgroup.com. Each lawyer's schedule is available, so you can book it. You don't have to any interaction, and you can submit the necessary documents for us to review it. So before you come to the interview, before you come to the consultation, we have all the information, makes our job very easy to have a consultation with us.